Welcome to the Ask the Experts show with local experts in the fields of legal, health, financial, and home improvement. Enjoy being educated in such topics as personal injury law, community association law, family law, bankruptcy law, along with health show topics like pain management, men's health, and dental implants. Now, sit back and enjoy today's Ask the Experts with host Steve-O.
Hey, welcome to Ask the Experts. Today's show is going to be probably one of our best shows only because it is our association law show, which our phones ring off the wall every month when they come on. They're on the first Thursday of each month. We're waiting for Robert Kaye of Kaye Bender Rembaum to come on with us. There he is. And we are going to be, we have got so many questions today, Robert, everybody wants to know what's going on. Because is there a new law that went into effect June 1st?
Not really a new law. People get confused with the way things have been developing in the area of emergency powers. The Division of Condominium had put out a statement some time ago that was interpreting certain statutory things that many people think they didn't have the authority to do in the first place. And then they issued a rescission of that order that became effective this week that caused further confusion. But the bottom line is that it really was of no legal consequence. The associations have the power to do what they need to do, and they should be exercising whatever they need to do to keep their communities safe and the residents from getting the COVID disease.
Gotcha. If you'd like to call in, which we get so many calls for this show, the number here is 888-565-1470. We are heard on 1470 AM, 95.3 FM, 103.9 FM, and 96.9 FM. You can also go to kbrlegal.com and watch the show, or you could go to Ask the Experts, Steve-O host, and watch the show on Facebook. And again, if you'd have a question of community association, HOA association question, you can give us a call here at 888-565-1470. We got a lot of emails of people who have been going to your classes online who really enjoy those.
Well, we actually have three that are coming up later this month. Starting next Thursday at 5:30 to 7:30 p.m. There's an online course for Condominium Association Board Certification by Allison Hertz out of the Palm Beach Gardens office. That's going to be in conjunction with Campbell Property Management, which will have a segment on board member best practices during the course. So registration is available on our website. You go to KBR-Legal/seminars and you'll find the opportunity to register. Because of limitations with the video online meetings, we are limited in space, so it's important to secure your position as early as possible. On Tuesday, June 16th, we have guest restrictions and screening tenants and new owners at 1 o'clock p.m., 1 o'clock to 2 o'clock p.m. That's going to be taught by Andrew Black and Karina Shea out of our Fort Lauderdale, or Pompano Beach office, near Fort Lauderdale. And Wednesday, June 24th at 1 o'clock to 3 p.m., there's the HOA board member certification, which will be taught by Emily Gannon, also out of the Pompano Beach office.
Well, we love hearing from board members, or if you live in an association and you have a question for Robert, you can call us at 565-1470. And what we always do is we take the emails that we get over the month and we ask Robert, by the way, this is a live show. Most of the shows out there are pre-recorded. This is a live show. So yes, you can call in right now for the next hour at 888-565-1470. Boy, we've got a lot of questions for you. But first of all, tell everybody about your firm.
Well, Kaye Rembaum is a law firm that concentrates in the area of community association representation out of 3 offices, Pompano Beach, Palm Beach Gardens, and Tampa. We provide all aspects of community association, legal representation, be it in interpreting the provisions of the governing documents, providing legal opinions as to that, getting involved in enforcement, covenant enforcement, assessment enforcement through lien and foreclosure, contract review, negotiation, construction lien law issues, litigation that may involve construction defect, or it may involve contract issues with third parties. It may involve representation before local city or county boards for whatever issues that may come up. So it's pretty all-encompassing for everything that a community association will deal with on a day-to-day basis.
There's a lot to know.
There is, and it's always changing.
Let's go to our first email. It's from Bonnie in Boca Raton. She
Hey,
said,
Bonnie.
are potential buyers allowed to attend a board meeting before purchasing the unit?
Well, board meetings for condominiums, HOAs, and cooperatives are pretty much the same under the statute. The only people who have an entitlement to attend, besides the board members, are the unit owners. The board members, by policy, can allow outsiders to attend, but under the statutes, only unit owners have a right to actually attend and participate in the board meeting. So a prospective purchaser may request the opportunity and the board may agree to allow it, but even if they could attend, unless invited by the board, they wouldn't have a right to speak. So that should be kept in mind as well.
Okay. Phone number here is 888-565-1470. Here's Gabe in Hollywood. He says, as it stands, there are several requirements that may prohibit our community from reopening most of our amenities. How does the board comply with the proposed requirements within a budget not designed for what is being mandated?
I'm not entirely sure what Gabe is asking, but I'm going to speculate that he's thinking that there's a budget that contemplates spending money on certain things and maintenance of certain parts of the community that are currently closed down. The association budget is not written in stone. It's an estimate of what the expenditures for the association in any given year are going to be. And it may be more or less than what the board projects for each given item. And that's fine. Sometimes there's money left over at the end of the year. Sometimes the association underestimated and may need to make it up in the next budget year or do a special assessment during the current year to cover whatever shortfall may exist. Certainly there's also problems when it comes to whether or not people are paying their assessments. It's extremely important for owners within community associations to continue to pay their regular assessments even under the current conditions, because although mortgages may be under certain limitations on foreclosure these days, community association assessments are not. And you don't want to risk being involved in a lien and possible foreclosure action, because the costs involved with that can become pretty expensive pretty quickly, and it's not really worth it. If you're having financial issues, it's important to bring those to the attention of the management of the community, most likely the board, uh, early on, and try and make sure you work out arrangements before the matter gets turned over to the association attorney for collection actions.
Before we go to break, what kind of questions are you getting from your clients mostly?
Well, I'd say the main issues are involving the rolling out of from the quarantining into a slightly more open atmosphere. The phase one aspect of it, things that they can do and can't do. Initially, community pools were closed down, and a number of amenities, and then the counties have relaxed some of those, but have set up specific requirements in order to meet county minimums to operate. And it's important that whichever county the community is located in, the board be familiar with those requirements because they're fairly specific, and make sure that they're in adherence to them at all times. One of the big concerns people have is the exposure to liability. If somebody makes a claim that because the association had opened up their amenities, and the person somehow contracted the COVID virus, does that mean they make a claim against the association? In all likelihood, there's no insurance coverage for that type of a claim, so it's certainly not something the association would like to find itself facing, with hungry lawyers trying to bring those types of claims for people. It's a hard thing to prove on the side of the unit owner, but it doesn't mean it can't get involved in expensive litigation in the process.
We're going to take our first break. Robert, give everybody the phone number at the office as well as your great website.
You can reach us at 800-974-0680. That will give you access to all three of our offices. You can also find us at kbrlegal.com. You can email us at info@kbrlegal.com, and somebody will respond to you. We're certainly open for representation of any community association in need of legal assistance.
Okay, we're going to take our first break and we'll be back with Robert Kaye of Kaye Bender Rembaum.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
And we are back. This is the Ask the Expert show. I am host Steve O. We're on every Monday and Thursday from 6 to 7 p.m. with local experts. Today's show, it's always the first Thursday of the month. Kaye Bender Rembaum. They are community association lawyers right here in South Florida. 3 offices, one in Pompano, one in Palm Beach, and also one new one in Tampa. So we got our first call. How's that?
I said it's been a year.
So let's go to our first call. Let's go to Jeff. Hi, Jeff.
Hey guys, good evening. Um, what, Robert, what do you think some of the good that's going to come out of this COVID-19 with regards to what new normals might be in community associations, like maybe increasing usages of volunteers, maybe online meetings become the new normal, and in addition, what do you think? What do you want to be some of the good things? What do you want to become the new normal as a law firm?
Well, Jeff, that's a good question. I think that from what we're seeing, the electronic meeting format has a lot of benefits that communities are experiencing. They're finding more participation of owners in the process, but in places that are contentious with some of these systems that are in place, the person in charge, the host, has the capability of maintaining order and only recognizing uh, individuals to speak one at a time, so that can help control what otherwise might become a chaotic meeting situation. The
Right.
bigger problem at the moment is that the the legislation in the area doesn't provide for, in a clear and specific manner, to have the electronic meetings for the membership meetings. Uh, Board meetings are a little bit easier toward that, but membership meetings are a little bit out there. Now, under current circumstances, I think there's no real problem in doing it because of the situation that we're facing with the stay-at-home orders and the virus still being fairly rampant out there. So I don't think there's going to be any kind of a legal problem with meetings of that type. But I think it's going to be necessary for the legislature next year to uh, have something added to the statutes to authorize meetings to be handled in that fashion. In the long term, it's hard to really project how much good we're going to get out of this because while people are acting in the way they are currently, when things go back, hopefully, to a more normal situation, say a vaccine is developed and the virus concern becomes far less, then I think people have a tendency to get back to the way things were.
Okay. Well, thanks for continuing to be there for all of us. You have a nice evening. Stay safe.
Thank you, Jeff. Thanks for listening.
All right. Bye now.
So we got a lot of questions. Thanks, Jeff. We got a lot of questions about um, social distancing as it refers to as it with HOA and condos. Are they talking about restaurants at
Well, I
the,
think
I guess it,
that in a lot of, it's difficult in different settings. In a condominium, where you have, let's say, a high rise with common areas, the social distancing internally is a concern on how people are able to do that. Everyone has a right to the facilities by law, but they also have to be smart about it. And not everybody lives in the same household, even though they're in the same building. So it's important that people are mindful of the concerns and do what they need to do to protect others. And that would include wearing a mask if you're in the common areas, and certainly on the inside. Outdoors might be less of a concern, but certainly indoors. And some communities do have restaurant facilities, but those are also under county orders on how they can operate and the social distancing required there. So that certainly it's a thing I think people are very familiar with now, the way things have evolved in the last couple of months. And it's just a matter of maintaining that throughout the rest of the time we're having to do this.
had three or four actually board members that wrote us wanting to know about with all the changes that have been made now with how business is done. Do you see any new laws changing for next year?
Well, they're in the process now of creating the legislation that will be presented next year. And I think, as I mentioned a couple minutes ago, the one that we anticipate seeing first and foremost is clear authorization for the electronic meeting format for the membership meetings. We've already had the ability to do electronic notices for meetings. We've also had the capability to do electronic voting if people follow the statutory procedure to get that set up. In our experience prior to this year, that has not been something that associations have jumped on in great numbers, some here and there, but I think that might be something that we see people taking greater advantage of in the future.
Wanted to get this is from Greg in Palm Beach. He said, with everything going on in the Palm Beach County pandemic, to riots, which I did not know how bad the riots got in Palm Beach. I'm so busy watching what's going on around the nation. And now this is hurricane season. Can we call your office as a board member to help us with decisions? Because it seems like decisions are going to be different than they have been in the past.
Well, that's
Sounds
one
like
of our
somebody wants
primary
to hire your
purposes.
firm.
That is a primary function of the law firm, is to be available to handle day-to-day questions that board members have in dealing with situations that are transpiring. We do have a triple whammy going on with the virus and the demonstrations and the protests, as well as the hurricane season. Granted, we don't have any hurricanes at the moment, but that doesn't mean we're
Don't say
only
that.
at the beginning. We're only at the beginning of our season, so that's always got to be in the back of our minds, or maybe not so far back.
Well, if give everybody your phone number, we're going to go to break and give everybody your website address. Your website is amazing. It has got so much great information on there that it is just a great tool to use. Give everybody the phone
Well,
number
thank
and the
you.
website.
You can get our website at kbrlegal.com, and the phone number to reach our office is 800-974-0680.
And I want to throw in there and that how important customer service is with your firm. That because you hear about people, so they put a phone call in and to their law firm, and it took 5 or 6 days to get back to them. And you are really on top of your customer service with your firm.
Oh, absolutely. We return the calls the same day, unless the attorney's not in the office, and somebody will acknowledge. A lot of what we do is done by email as time goes on, which is faster, and but we also reply to those very promptly. And it's always been our philosophy to be responsive to our clients' needs, timely and efficiently and cost effectively, in a manner that's understandable to the layperson.
And many of your lawyers within the firm are also board certified.
Well, last count, 9 of the 19 attorneys are board certified. We just had one who was out of 6 in the state who achieved that certification just last week. So we're very proud of her. Not all of our attorneys do general association work, so the board certification for them isn't something that would be expected, but almost all of our general association attorneys are currently board certified.
Which means you can
I don't
actually
know of
call
many firms
yourself.
that can take it.
Yeah, you can actually call yourself an expert. Let's go to break. When we come back, we'll have more with Kaye Bender Rembaum We have one of the senior partners with us, as always, each month, Robert Kaye. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum, a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Bender Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Bender Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680. You are listening to the Ask the Expert Show with host Steve-O. We will be right back with more experts in the field of legal, health, financial, and home improvement. Join us every Thursday from 6 p.m. Now, get ready for more Ask the Experts.
Boy, if you live in a condo association, HOA association, this is the greatest show. Listen to it actually has our largest audience, and we are so, I guess, blessed to have the Kaye Bender Rembaum law firm. Great law firm, and basically this is all you do. I mean, you do some title work, but this is basically, you don't have 20 different shingles hanging up.
No, I'd say better than 90% overall in the firm is done community association orientation.
We just had, during the break, we had someone text me wanting to know, do condo docs expire?
Condo documents do not expire under the Marketable Record Title Act, which many people are familiar with. It's a statute in Florida that provides for certain documents in the public records to expire after 30 years unless they are preserved prior to that date. Condominium documents may have an automatic termination provision in their own terms, but without that, then they would not terminate under the Marketable Record Title Act. And there's very technical reasons as to why that is, but basically they are excluded from that statutory problem. HOA docs is another story. If you have an HOA that's approaching 30 years of age or older, you would need to get in touch with your community association attorney to make sure that you haven't missed the time for that. If it goes beyond the 30 years, it becomes a little more involved with homeowner participation in order to resurrect those documents. So it's best to get that done before that 30-year time frame expires.
Okay. We had Vic in Boca Raton who has a renter living in his home who has now added additional people. He wants to know, do you have to go to an arbitrator to get the extra people who aren't on the list to be removed?
Well, if the association desires to cause the removal of an unapproved occupant, if it's a renter who's in there who shouldn't be, that's an issue that is not within the jurisdiction of the Division of Condominiums Arbitration section. That would be straight to the county court system, wherever the community is located. So you'd have to file, depending on how your documents are written, either an action for an injunction to compel the owner to remove the unauthorized occupant, or if the documents allow, then the association can evict on its own.
Seems like it's a big hassle to have somebody removed from your own house. But like he said, the renter is okay who's on there, but he has allowed others to come in with him.
Well, if the owner himself wants to do it, that's a different issue. That's more an action of ejectment or eviction, depending on the circumstances that they're in. And that's not something that involves the association unless the board is telling them they have to do it. Whatever they do, they should get an attorney familiar with that area of the law involved to assist them, because the law tends to favor the occupant more than the owner, even though their interests are far less. Courts don't like to throw people out of their homes.
Yeah. Harold from Boca Raton wrote, "Love your show. I listen to it every month." He said, I'm in an HOA, and they want to paint and clean the roofs of our house. Can I tell them I want to have my own painter and roof cleaner? Or do I have to use theirs?
That's going to be a document specific issue to their community. From what he's described, it's a situation that sounds like it's an association responsibility under the governing documents, and the board is working to do that. Typically, if you've got a situation with connected units, townhome units that share a common roof, it wouldn't make as much sense to have the individuals do it on their own, because they might do it at different times, and then you've got a checkerboard look throughout the community that is not necessarily desirable. So having a uniform appearance and a uniform job being done, not to mention the likely economies of scale of doing many over one at a time, might make it a less expensive proposition. The association does take on additional potential liability when they're doing the exterior maintenance on the property, but they also have insurance to protect the community in those situations.
You remember when we used to get so many calls about service animals? We very rarely get those anymore. But here's a question from Lou in White House Point. We all listen to your show. They listen to your show in their card room, which is nice. I'm glad they do that. That means there's more than one
Make sure you
person.
socially distance.
Yeah, if a service emotional support dog doesn't bark or bite and we pick up after them, can we go anywhere on the property?
Well, the basic rule of thumb is that emotional support animals, which are protected under the federal and state fair housing laws, are entitled to go virtually everywhere that the unit owner who needs the support animal is entitled to go. There may be certain exceptions, like perhaps in the pool, or if there's a spa, sauna, or possibly the gym. But generally speaking, if the association tries to limit where the emotional support animal can go, that can put them facing a charge of discrimination, which it's a process where you're guilty till proven innocent, and you don't want to be there if you can avoid it. So we don't recommend that limitation. If there are emotional support animals in the community, we suggest that the board adopt a package of application documents and rules and regulations that we can prepare on their behalf for them, that will cover all the bases and provide them the most legal protection that we can under those circumstances. And that's a highly recommended approach to take.
Okay. Here's Clovis in Miami. She said, I guess it's a she. She said, I'm on my board. The law says once you serve 8 years in a row, you can't go for a ninth year. When did the 8 year clock start? Is there any way I can run the ninth year?
Well, this is a question that comes up regularly. You may recall we've talked about it on the show before. This was a statute that was adopted in condominiums only in 2018. And the way the law was drafted and the way it was put on the books means that the clock for the 8 years started to tick on July 1, 2018. So anyone who got elected after July 1, 2018 would have their 8 year consecutive term limit start. So it wouldn't kick in as a problem until 2026, after July 1, 2026. Even with that limitation, the statute provides an exception that if the board member who's serving the ninth consecutive year gets the vote of more than 2/3 of the unit owners, or there isn't enough volunteers running for the board to fully seat the board, then that owner can continue to serve. But that won't happen
Okay.
until after 2026.
Okay. Can you go over your schedule before we go to break?
Sure. We have 3 courses online in June, and the online courses are getting nice responses from the participants. And they're during, well, actually one's an evening one, but 2 are during the day. So on Thursday, June 11th, next Thursday, 5:30 to 7:30 p.m., the Condominium Association Board Member Certification course will be taught by Allison Hertz. Campbell Property Management will be in conjunction with her, and they'll have a segment on board member best practices, which is certainly helpful to new board members in getting acclimated to their duties. On Tuesday, June the 16th at 1 o'clock till 2 o'clock, we have guest restrictions and screening tenants and new owners, being taught by Andrew Black and Karina Shea out of our Pompano Beach office. That's got some continuing education credits for managers, so that one can be a very interesting one. And then on Wednesday, June 24th at 1 p.m. to 3 p.m., the HOA Board Member Certification course will be taught by Emily Gannon, also in our Pompano Beach office. There's CEOs for that as well, or CEUs. It's a 2-hour course, and you can find them all at kbrlegal.com/seminars, and the sign-up information is there as well. I think there's 100 participant limitation, and we are seeing higher attendance at our online courses, or at least people are signing up for them. Whether they actually click go when the time comes is not necessarily the same thing, but since there are only 100 available seats, we hope that those who do reserve a spot do attend, because we want to keep someone else from attending who otherwise might miss it. So check on the website, kbrlegal.com/seminars.
Will you be emailing free refreshments to them?
Unfortunately, we can't do the refreshments on the online ones, but we will be emailing
Okay.
blasts out of the upcoming events.
Okay. We're going to go to break, our last break, and we come back. We have more with Robert Kaye of Kaye Bender Rembaum. We'll be right back.
Is your community association looking for prompt, effective, cost-efficient, and understandable legal advice and services? You'll find that and more with Kaye Bender Rembaum. a full-service commercial law firm concentrating on the representation of more than 800 community associations throughout Florida. With offices in Broward and Palm Beach counties, Kaye Rembaum assists clients in all matters of association representation, including but not limited to collection of assessments, contract negotiation, covenant review and amendment, covenant enforcement, and construction defect claims. Under the direction of attorneys Robert Kaye, Michael Bender, and Jeffrey Rembaum, Kaye Rembaum is dedicated to providing clients with an unparalleled level of personalized and professional service regardless of their size, and takes into account their individual needs and financial concerns. For more information, visit www.kbrlegal.com or call 954-928-0680.
We are back. This is the final 15 minutes of Ask the Experts. This week's show is with the Kaye Rembaum Law Firm, one of the largest community association law firms in Florida, not just South Florida, in Florida. And we are always so lucky to have Robert Kaye, one of the senior partners, with us. Do you still get questions about the website? Does everybody have their website up now?
No. We get questions, and not everybody has them up.
Are they doing it? I mean, can they do anything? Have anything done to them if they don't have their website up?
In my experience, I haven't seen it be a priority with the division on enforcing on that as of yet. That the division could impose a fine against a community that doesn't have the website who's supposed to. They need to keep in mind it requires a condominium association that handles 150 units of a single condominium or more. So if you have a condominium association that's handling 3 condominiums, each with 50 units, that does not mean the same thing as 150 of a single condominium. So it's important to know whether you actually are required by law to have it. But a website is not a bad idea for any community association to have, to provide access to specific things to the unit owners and provide a way for communication to be greater.
Hey, let's go to our phones. We've got Barry on the phone. Hi, Barry.
Hello. Hi, how are you? Yeah, great.
Good. How are you doing?
Great show. Good.
Thank
We
you.
have a declaration that was effective in 2002 with a 1 month minimum short-term rental. We do not have Kaufman language, and we want to extend the 1 month to 6 months. Can we make an argument that that change applies to all unit owners, even unit owners who didn't approve of the change?
You say your condominium was established in 2002?
Yes, it was before the 2004 law that had that special restriction limiting amendments to short-term rentals.
Well, Barry, that's a very sophisticated legal position and an opinion that I've recently given to some clients that, in fact, without the Kaufman language, there's a very good legal argument that that limitation in the statute does not apply to your condominium, and that if you were to provide limitations on leasing, it would apply to all the units and not just those who voted in favor of it, as the statute provides, or those who take title afterwards.
Okay, can I ask you one more question?
Yeah.
So are you basically saying that that's a substantive provision and not a procedural provision?
In my opinion, yes. It's substantive and involves the use of a unit. It doesn't get much more substantive than that.
Okay, I just want to add that that's a difficult question. I'm a former pension lawyer. No other lawyer discusses that issue when they discuss Kaufman language and short-term rentals. You're the first lawyer who's discussed it, and I think you discussed it greatly and accurately.
Thank you.
Thank you very much.
Thanks,
All right,
Barry.
thanks for listening.
Wow, that's a nice compliment. Let's go to another phone call. We've got
I was
Jack.
happy to come up with that.
Hello?
Hi, Jack.
Yes, how are you? Yes,
Good.
a quick question for the attorney. We live in an HOA here in Weston, and the violations committee is entirely made up of board members, and we believe, a few of us, that they are applying the laws not uniformly. We believe they are selecting whom to address and send notifications. And their own houses are, in violation, but obviously they're not sending to. Is there any recourse to see what violations have been sent out, what notices, or they're strictly private matters?
The official records of the association would include information of that nature, which should be made available to any requesting member who submits a written request for access to the records and to inspect them. There is
really?
potential hiccup in that issue, in that currently I know of a number of communities that, because of the corona situation and the inability to do social distancing during record inspections to the amount necessary, they may be delaying providing the record inspections until such time as it's a safer environment to do so.
Mm-hmm.
Any challenges to that as of yet? I'm sorry?
So they are public records. They can be inspected.
Well, they're not public, but they're official records, so they're available to the members of the association.
Okay, right. They are available to members.
Yes.
Okay, wonderful. That's great. Thank you so much, and I enjoyed listening.
All right, thanks.
Thank
Keep
you.
listening.
Thanks.
Bye-bye. Bye-bye.
Got some new fans.
Hey.
Got some more questions here. Wow, we got a lot of questions since your last show. Here's
Save
Kim
'em.
Davy. She's a condo building. Are there many documents a developer has to turn over to the new board? What are some of the most important records they have to turn over besides the money?
Well, the money is important, as are the records that support the money as reaching the condition that it is. So they are supposed to do a review of the accounting records of the association. Independent certified public accountant is supposed to do that on behalf of the developer, and the new owner control board should be doing that as well. But there's actually a list of documents that the developers are required to provide in the statute in Chapter 718. It's a lengthy list, which I have to tell you, I don't have it all committed to memory. But some of the documents that are in there are the, of course, recorded governing documents of the community. Also, the as-built plans and specifications of the building, so that the community is able to see everything that was placed and where it's placed and how it was placed. Those are the principal things that come to mind at the moment, without pulling up the statute, which I'm trying to quickly do. But the statute is big. But I do suggest that get with the association attorney, or if you haven't gotten one, get one that is familiar with the area and then in the statute, I believe it's in 718.501 or 502, you'll find the specific listing of all the items that developers required to turn over at the time. Or possibly 202, let me see.
I hope you don't mind. I gave Kim your phone number.
That's fine.
While you're doing that,
It's in the 500s.
okay, we just kind of follow up with a developer question. It says, I'm the new president of our condo association. Is there a statute of limitations to go after the developer?
Yes, there is. It's a number of items. Many of them are 1 year from the transition of control from the developer to the unit owners. That's a key time frame. There's another 3 years from the issuance of a certificate of occupancy, but if the 1 year comes later, it will be extended beyond that. If there's latent defects that you cannot see or ascertain without more investigation of a destructive nature, then it could be a 15-year statute of limitations. So depending on your issue, you're generally going to want to stick with the 1 year from transition for most, because those are the more significant issues that you're going to be addressing, and everything else will fall into place.
Okay. So here's another question. I think you answered it several months ago about the police car being parked at the, I guess it's a condo, but a guy wants to know if he could park his ambulance there too.
Well, I
They're
don't
trying to,
think there's been any specific determination regarding ambulances as opposed to police cars. Police cars are commonly considered acceptable and not falling under the realm of commercial vehicles. Ambulances is not something that I've ever heard as an exception to that. So I would say most likely that's not protected.
okay. You know, I always like to kind of end the show with, because I know there's a lot of board members, uh, property management companies that listen to the show. Why should they retain your firm?
I already hear the music playing.
I already hear the music.
We have
Tell them how great
many
your service
years of
is.
experience, many years of experience among a great number of our attorneys. We have a customer service orientation in the practice that we provide, and we are accessible and the type of attorneys that are most helpful to community associations, and I don't feel like I have enough time to tell you it all right now.
I know.
Use it this point.
Listen, thank you for coming on.
Had to ask that a
Kaye
little
Bender
sooner.
Rembaum. We'll see you again next month.
See you next month.
Stay
Thank
well.
you.
Thanks for listening to the Ask the Expert Show, featuring interviews with local experts in the fields of legal, health, financial, and home improvement. Call our office at 888-574-6999 to become one of our experts on the show. And tune in again next week for more Ask the Experts with Steve-O. The opinions expressed on the